Hello students, please subscribe the channel, drop a like, share and comment. This is exercise number 25 of the Progressive Monthly Magazine, March 2023 on the speed of 100 words per minute. Start. Having considered the reasoning given by the learned arbitrator, we are of the opinion that the interpretation by the learned arbitrator was both possible as well as plausible. Therefore, merely because some other view could have been taken, the High Court is not justified in interfering with the interpretation made by the arbitrator, which has observed was possible and plausible. Therefore, in the facts and circumstances of the case, we are of the opinion that the High Court has clearly exceeded in its jurisdiction in interfering with the award passed by the learned arbitrator with respect to claim number 1, price adjustment and escalation. At this stage, it is required to be noted that though the High Court has observed that the award passed by the learned arbitrator with respect to claim number 1 was against the public policy, with respect, we do not see any element of public policy. It was pure and simple case of interpretation of the relevant clauses of the agreement, which does not involve any public policy. Therefore, we are of the opinion that the impugned judgment and order passed by the High Court for quashing and setting aside the award passed by the learned arbitrator with respect to claim number 1, price adjustment and escalation cannot be sustained, and the same deserves to be quashed and set aside. Now, so far as claim number 2, fixed costs and an amount of rupees 78 crores awarded by the learned arbitrator with respect to compensation of loss is concerned, having gone through the relevant material on record, we are of the opinion that the High Court has rightly set aside the award passed by the learned arbitrator with respect to claim number 2. Except the CA's certificate, no further evidence had been led with respect to actual loss. Considering the material on record, it is on the contrary found that in the relevant year the quantity of the coal lifted by the respondent was much above the fixed quantity. Thus, the award passed by the learned arbitrator with respect to claim number 2 was contrary to the evidence on record and therefore is rightly set aside by the High Court. Similarly, even with respect to claim number 3, escrow account is concerned, the High Court has rightly interfered with the award passed by the learned arbitrator with respect to claim number 3. It is required to be noted that the escrow account was required to be opened as per the guidelines issued by the Ministry of Coal, Government of India for the preparation of mine closure plant. The guidelines required, inter alia, the mining company to open an escrow account with any scheduled bank. Accordingly, the respondent opened an escrow account and executed an escrow agreement. From the correspondence between the parties, it appears that even the appellant consented for opening the escrow account. The appellant also agreed that the amount to be deposited in the escrow account will be recovered by the respondent from immediate next payment of the coal bills of the joint venture company PKCL raised towards dispatches of coal from appellant's coal blocks. Thus, thereafter, it was not open for the appellant to claim the amount lying in the escrow account. If the amount lying in the escrow account is returned to the appellant, the purpose and object of opening the escrow account, which was as per the guidelines of the Ministry of Coal, would be frustrated. The object and purpose of opening the escrow account was to see that the appellant company fulfills the contract as per the agreement and till the closure of the coal blocks. Therefore, the High Court has rightly interfered with the award passed by the learned arbitrator with respect to claim number 3 escrow account by observing that the reasoning is perverse or so irrational that no reasonable person could have arrived at on the material and evidence on record. We are in complete agreement with the view taken by the learned division bench of the High Court. In view of the above and for the reasons stated above, the present appeal succeeds in part. The impugned judgment and order passed by the High Court insofar as quashing and setting aside the award passed by the learned sole arbitrator, confirmed by the learned commercial court, insofar as claim number 1, price adjustment and escalation, is hereby quashed and set aside, and the award passed by the learned arbitrator with respect to claim number 1 is hereby restored. The impugned judgment and order passed by the High Court insofar as quashing and setting aside the award passed by the learned arbitrator with respect to rest of the claims, namely claim number 2 fixed costs and claim number 3 escrow account, is hereby confirmed. The present appeal is partly allowed to the aforesaid extent only. However, in the facts and circumstances of the case, there shall be no order as to costs. This is the final judgment of this court now.